Hi there. Welcome. Thanks for joining me. I'm Marc Spindelman. I teach at The Ohio State University's Michael E. Moritz College of Law. I'm here to share some new work with you on the LGBT Title VII sex discrimination cases presently pending before the U.S. Supreme Court. All right, here goes. Title: The Showers Return. A serial essay on the LGBT Title VII sex discrimination cases, Part 1. A quote from Susan Stryker. I am not the water. I am the wave, and rage is the force that moves me. In birthing my rage has rebirthed me. Introduction. As we await word from the U.S. Supreme Court on whether Title VII of the 1964 Civil Rights Act protects lesbian, gay, and trans workers when they suffer sex discrimination at work and legally complain, it's worth essaying some of the more striking features of the LGBT Title VII cases as they were litigated before the Supreme Court. The present interest in these developments involves neither a wish nor an expectation to influence the judicial process. That'd likely be pointless anyway. The outcome of the LGBT Title VII sex discrimination cases is assuredly set in basic form by now. Instead, the interest here corresponds to a desire to record how anti-LGBT forces have conducted themselves at a moment when they apparently think that they have a newly receptive audience in the form of a jurisprudentially and socially conservative majority of the Supreme Court. This conduct and the probabilities it involves ought to be of immediate concern to liberals and progressives committed to sexuality, trans, and other intersecting inequalities, quite aside from the legal effects that these attempts may yield in the present cases. If the near-term and longer-term futures for LGBT and sex discrimination rights and interests are uncertain, the litigation strategies developed and deployed against LGBT positions in the Title VII cases are not. They revealed anti-LGBT forces boldly articulating arguments that draw on and play to not only rule of law conventions like logic and reason, but also to elements in the U.S. cultural archive that reanimate fantasy nightmares of LGBT rights as portents of hellish gender and sexual deviance run amok. Deviance that on its surface anyway is racially marked as white. It's been more than a generation since fantasies like these commanded a majority of the Supreme Court in a case involving lesbian and gay rights, but that possibility, a possibility in which time flows forward to the past, currently stares the American public in the face. All these dynamics and all these actors have become part of the context against which the LGBT Title VII sex discrimination cases will be decided. Whatever the Supreme Court's results, the cases will be the next step in an ongoing jurisprudence of lesbian and gay rights that may continue in pro-LGBT, including expressly pro-trans directions, or that may shift course, having elsewhere exhibited signs of a legal slowdown since Obergefell against Hodges, the landmark right to marry decision. If on the distant horizon, representations of the closet can be glimpsed starting to take shape, they have in certain respects arrived herald-like in the LGBT Title VII sex discrimination cases. Happily, the prospects that the legal system will once again reopen, repopulate, and repolice the closet in something resembling its historical forms is broadly inconceivable, but it is still time, as the Supreme Court's next term takes shape, for pro-LGBT forces to consider reconvening as broad-based and engaged political publics, ready to challenge the closet's distantly re-emergent strictures and the forms of inequality they intersectionally involve. These new cases demonstrate that the closet's relegation to historical artifact is not to be taken for granted or assumed to be legally guaranteed by the U.S. Supreme Court, especially not when the Supreme Court, as in these cases, silently witnessed and tolerated deceptively genteel professional arguments that traded in cultural fantasies in which trans and gay people are variously being symbolized as social forces bent on the ruin of innocent cis heterosexuals, both women and men, as well as the destruction of sex itself, all of which thus need the law, including measures like Title VII sex discrimination ban, to protect them. Should the Supreme Court even subtly endorse these cultural fantasies when ruling in the LGBT Title VII sex discrimination cases, it could indicate a wider future path of destruction of the legal gains that lesbians and gay men have achieved under law to this point, imperiling the conditions of legal and social life for others inside the LGBT communities, including for trans people, as well as outside of them, where the cases interface with wider protections against sex discrimination on the traditional terrain of cis women's equal rights. For now, what there is to attend to is what happened at the Supreme Court, and what can be discerned about how these developments may construct various possible futures. The overarching argument of this work, which will unfold across its serialized pieces, is as follows. Part 2 substantively begins by spotlighting the connections between the different Title VII sex discrimination cases before the Supreme Court. In addition to introducing some of the case basics, discussion here involves an account of the distinctive significance of the trans sex discrimination case. It identifies a key set of defense arguments organized around not simply bathrooms, but specifically ladies' showers and locker rooms, which served as a normative touchstone for the defense's case against trans sex discrimination rights under Title VII. Next, Part 3 takes a closer look at the defense's renderings of the shower and locker room scene in the trans sex discrimination case. In detail, it traces the teachings of the defense's portrayals of ladies' showers and locker rooms, which figure trans women as an invading social force in order to critically expose the unmistakable and deeply transphobic and sexist suggestion that trans women, or some of them, pose an embodied sexual threat to cis heterosexual women that, if not criminal, is crime-like. It also shows the multiple layers of transphobia and sexism working within this argument, including against cis women and their interests. Part 4 then turns away from oral arguments to explore a policy claim advanced by the defense in briefings submitted to the Supreme Court that subtly but palpably involves a bid to repsychologize and even repathologize trans identities and trans people. Problematic on its own, this bid shows what some who oppose trans rights in the case thought and hoped the Supreme Court might tolerate and possibly credit as valid, rational, non-animus-based legal reasoning that could properly drive an anti-trans outcome in the case, along with the public reasons given for it. For its part, Part 5 delivers an account of the shower scene's genealogy. It looks at the appearance of the shower scene in the sexuality as sex discrimination cases, and surfaces thinking about its antecedents in ways that recover some of the shower's enduring cultural logics, as well as its non-obvious stakes. Having recovered these resonances, Part 6 proceeds to leverage them to survey different ways that anxieties, sometimes panics, about gender and sexuality confusion were expressed during oral arguments in both the sexuality and the trans identity cases, from both bar and bench, concerns that relate to the perceived stakes of recognizing sexuality and trans sex discrimination rights, and what those forms of legal recognition are thought capable of doing to the organization of social relations and social life centered around male-female sex difference and the various hierarchies built atop and otherwise related to it. Discussion across various parts of the work develops a picture of the LGBT Title VII sex discrimination cases, in which they function together through the shower scene as a larger set piece in which pro-trans, pro-lesbian, and pro-gay sex equality claims are representable and represented as functionally fungible threats, queer threats, to existing gender and sexual orders. Part 6 also concludes by engaging the stakes of these cultural myths and the imperatives of addressing them head-on while looking to the future of LGBT rights, no matter how the Supreme Court rules in these cases. Next time, some preliminaries on the LGBT Title VII sex discrimination cases. Thanks for joining me. I look forward to seeing you soon.